Yes, Mr. Wheaton.
My lord and my lady, before the short adjournment, I was just about to move on to the joys of the letter of intent.
Yeah?
I'm going to take this point briefly because you've looked at it in a great deal of detail.
Yeah.
We say the letter of intent does amount to the agreement between the parties prior to the inset of the policy, that it was binding and it was binding to its full effect. And that is made clear by clause 5. And it also has the effect, as you've been taken to, of having the entire agreement clause as superseding all the previous negotiations upon which Conway rely. Now, my Lord, Conway's primary riposte to the letter of intent is to say that there's something about the project meeting on the 4th of July that imposes a new relationship of agency. Well, my Lord, we simply say the answer to that is that's not open to them on this appeal. On the basis of the judge's findings of fact, he expressly considered the meeting the 4th of July and concluded that it didn't reach two conclusions. First, it didn't assist them in relation to the scope of cover at all. And second, in his broader conclusion at paragraph 125, that there was no evidence which displaced the clear and obvious meaning of the parties' agreement. The second point I want to make in relation to the letter of intent is these are not unusual terms. It's JCT option C. This form of JCT option C has been around since 2005. By the time of this contract, it had been in use for years. Contractors know what they mean, employers know what they mean, insurers know what they mean, and there could be no doubt that when the RFU sent the letter of intent to Conway, that it was saying we intend to procure you cover on this basis. Well, the fallback, if it's not the meeting of the 4th of July, is Twintec. I'm not going to take you through Twintec for the reasons that Mr. Reid submitted. Twintec is authority for no proposition, other than one construes the letter of intent by its terms. What I would point out is that the form of contract in Twintec was a bare, unamended DON 2 form, which didn't have any of the terms filled in, whereas the form of contract here, which is the numbered document reference from Forster's at paragraph 3, is actually a full suite of amendments, including all the relevant parts of the JCT filled in, and the letter of intent expressly provided that all of its terms would be binding. Mm-hmm. But the second reason why Twintec doesn't assist Conway is that even if Mr. Gale were right, that there is a general proposition that only such parts of a letter of intent as apply to the particular work Conway is carrying out so as to prevent it being in breach of a subsequent ultimate contract. That doesn't deal with the express pleaded cases, the retroactivity of the JCT contract, nor, my Lord, does it deal with this. Even absent anything else, the letter of intent stands itself as an objective communication of the RFU's intention to procure option C cover. When construed against the background of the rest of the documents, that's made stronger by the information section of the risk details of the policy, which tells the insurer it's going to be option C, and then the parties enter into the JCT contract unamended. So, my Lord, that's all I'm going to say about the letter of intent. Mm-hmm. My third point was the relevance of the RFU's intention. And, my Lord, we say, we agree with RFU that there is no rule of agency and no rule of law or contract which provides that if a party is specifically named or identifiable, then questions of intention simply fall away. We concur with the cumulative requirements set out in Collinvo at page 397 of the authorities bundle, to which you've been taken. I don't need to take you back.
You've been referred to it. I'm not sure.
Well, in which case, let's
it was yesterday, and so I can't retain it. So just.
My Lord, it's authorities 397.
Yeah.
97.
397, my Lord.
Yeah, so you're quite right. We were taken, Mr. Garley took us to this yesterday. So these are the three.
These are the three cumulative requirements, of which, in fairness, only the first two are relevant. And what your lordship will see from that is the proposition or the situation being discussed in column though, paragraphs 1522, 1523 and onwards, do not differentiate, and they don't make the delineation that Mr. Gailey seeks to make between specifically named and unidentified principles. These are propositions of agency that apply in every case. We know we've got the question of authority, and partway through the paragraph, again, the lordship will say, unless there's specific, any provision in the contract between them which indicates B is to be personally liable for particular losses, potentially negates the argument that B is authorised A to insure respect to those losses. And then the second cumulative point, the primary assured intended to cover the interests of the third party. Again, at 1524, your lordships will see the proposition that that extends not only to an intention to obtain cover, but also as to the scope of cover. And my lords and my lady, the third proposition is on page 399. I take you to it just for completeness. The third proposition is that there should be nothing in the policy excluding the third party. The policy should on its face be capable of covering Conway. That's why we say the third cumulative proposition doesn't arise here, because it obviously does.
What about paragraph 15027? Mr. Garley placed considerable reliance on the intermediate situation identified in the second sentence. No authority is footnoted for that, but I think it was that sentence on which I think he said was his case in a nutshell, with B being Conway and A being RFU.
Well, my lord, may I say, I don't understand how it can be his case in a nutshell, in my respectful submission. The first sentence of paragraph 1527, if A has no authority to insure on behalf of B, then it is to be assumed A is not intended to do so and the policy is purely for A's benefit. Well, that's nobody's case here.
Yeah, I understand that.
The second sentence, an intermediate situation, is where B has authorised A to insure on his behalf, but has not required him to do so, in which case B must, if B is not listed as an insured person, rely, if he can, on the undisclosed principal doctrine. Well, my lord, we don't see anywhere in 1527 any reference to being listed as an insured person, removing the requirements of authority and intention. So, my lord, we don't see where that takes them.
Yeah.
And your lordship will note that there is no authority cited for that proposition.
I noticed that.
So, my lord, those are the cumulative requirements set out in column, which Mr. Reed's referred to in his submissions and which we adopt.
Yeah.
The reason we say that it is obvious that even where a principle is specifically named, the court may always need to inquire as to the scope of agreement is simply this. There are a lot of contracts which are not clear on their face and which require interpretation. If I may give you an example of an agency in which there are plainly named, identified, disclosed principles. Imagine that Mr. Gailey authorises me to procure 100 widgets on his behalf. And Mr. Reed gives me a specific instruction to obtain 20 widgets. And I enter into a contract that says, on my own behalf and on behalf of my principals, Mr. Reed and Mr. Gailey, I would like to buy 200 widgets. How many widgets does Mr. Gailey get? The answer is anything between 100, which is the minimum he's authorised me to get, and on one view 200, but if I have a separate relationship with Mr. Reed saying he's owed 20, then one assumes the court would accept that. How is the court to assess who gets what without an investigation of intention? And while we say the same principle applies when looking at a composite policy of insurance in a construction project, and this comes back to the question of rights and interests. So even if we say extended to its logical proposition, even if Conway is specifically named in the policy, all the policy would say in the definition of insured is Conway as contractor for the A071 works for its rights and interests. And the court still has to determine what those rights and interests are. And a similar point can be made, I'll deal with it briefly. I was going to take a slightly different point from Mr. Reed. Mr. Gailey says Barclays Bank is named because its name is on the policy. And he says they must therefore be able to participate in the policy in full. Now, Mr. Reed explained to you that in fact, Barclays only participates in the DSU cover, and in fact that cover was never taken out. But my question, just as a proposition on the face of the policy, is why does Barclays automatically take full cover? Because Barclays is only named for its rights and interests, and whilst it must be Conway's case that if there was an express term of the funding agreement limiting the scope of cover to be provided in relation to DSU, the court would be prevented from taking that into account. And we say that's not the right answer, and that's a remarkable result. So we say the question of agency is in fact referable to two, perhaps three questions. The first is there a relationship of agency at all? The second is, does the agent intend to enter into this contract on behalf of his principal? And the third is, what contract does the agent intend to procure on behalf of his principal? In other words, what's the extent or scope of the contract the agent intends to procure? Now, my lords and my lady, you've been taken to Magellan Spirit and Vitol. I don't think I need to take you back to it, but please let me know if I do. The basic proposition in that case related to a charter party with what I'm going to call a true undisclosed principal, where the agency itself and the identity of the principal were not disclosed on the face of the charter party. And Mr. Justice Leggett was considering the second question of intent in relation to the undisclosed principal doctrine, against the background of what did this principle, was this in fact an agent and principal relationship, and did this principal enter into this contract? Oh, so did the agent enter into this contract on behalf of his principal? Nowhere in Magellan Spirit is the court concerned with the question of the extent of the contract procured. And one can understand that, it's a charter party. They say that the whole charter party was entered into in reality on behalf of an undisclosed principal. And what you won't find anywhere in Magellan Spirit is any authority for the proposition that you don't look at the issue of intention where you have a disclosed principle. And for the reasons that Mr. Reed summarised and as I set out in my skeleton, we say that's important because it's Conway's case that it imbued the RFU with broad authority to procure insurance. So it's Conway's case that it was minimum terms that you could procure whatever, the RFU could procure whatever it wanted above that authority. Now, you've seen that the judge rightly rejected that case on the facts, but even operating on that hypothetical, the RFU could have procured a range of different insurances from the bare minimum JCT option C through to full fat cover under the CAR policy. What was the RFU's intention? And that is the task which the court is faced with. So, well, we say the base proposition that being specifically identified as an insured is simply wrong. It does not have the effect contended. The second point we make about intention is it doesn't matter because Conway is not specifically identified in the policy. And I don't need to go back to it, I can give you some bundle references. But as Mr. Reid made clear in his submissions, National Oil Well is on all fours with this case. It did concern a contractor who was appointed prior to the date the policy was written, who could be ascertained at the time the policy was written. And there is no difference in principle between the position in National Oil Well and the position here. And Mr. Justice Coleman in National Oil Well concluded that the appropriate approach was to consider the authority and intention of the agent. Mm-hmm. And if I can just take you to one small part of National Oil Well, if I can ask you to take up the authorities bundle and turn to page 84. And it's column 1, the top paragraphs from the top of the page down to what then was the subjective intention.
Yeah.
And the point that Mr. Justice Coleman makes here...
We start in the middle of a sentence, indeed in the middle of a word.
Indeed, well, perhaps go back to the bottom of page 83, where the submission is made by Mr. Falconer that it's impermissible to construe the policy of insurance by reference to the subjective intention of the agent. And Mr. Justice Coleman rejects that submission, says the purpose of this exercise is not to construe the policy, but to identify the extent of the intention. And then, partway down the page, after discussion of the views of Lord Justice Kennedy, he says, there can be no difference in principle between the case where the issue is whether a particular party has been bound to the policy as co-assured at all, and the case where the issue is whether a particular party has been bound for the whole or only part of the scope of cover. In both cases, the subjective intention of the principal assured can be directly material to the resolution of the question. Now, well, the only refinement we would put on that is we all accept that that is not the pure subjective intention of the agent. That's the intention of the agent to be discerned from objective evidence. And that is the effect, and the limited effect, we say, of Magellan's spirit. It is to convert what was thought to be, by Mrs. Justice Coleman, a purely subjective exercise, into an objective one. What it does not do is remove the requirement for the examination of intent.
Yeah.
And at the risk of trying the court's patience, I come back to, and that's the exercise the judge went to as reflected in his findings of fact.
Yeah.
In relation to rights and interests,
Yeah.
it's my fourth submission. I've reflected on this over the short adjournment. I don't think I can add anything to the analysis of the Master of the Rolls, your General Accident, and Mr. Reid's submissions.
You referred a little earlier to rights and interests. Obviously, Mr. Reid's submissions on that point were aimed at ground 5, but you have referred to rights and interests at least once in relation to the earlier points, effectively, the effect of RFU's intent. So, do you say that it's a broader point that assists your submissions on the approach?
My lord, it's a broader point than just being limited to ground 5. So the rights and interest point arises in two ways. First is specifically in relation to ground 5,
Yeah.
where the proposition is that the effect of the rights and interest provision allows the court to look at the parties' underlying agreement, and there's no substantive difference between rights and interests here and provisions to the contrary in national law.
Well, that's Mr. Reed's submission.
So that's the basic ground 5. What we say is that the rights and interests of Conway are not limited, as Mr. Gailey says in his submissions, purely to what is their insurable interest. And this is the discussion that my Lord and my Lord Justice Baker were having with Mr. Gailey yesterday. And whether or not that was a restrictive interpretation of the words rights and interests or a more relaxed natural interpretation. Mr. Gailey invites you to find that these are specific words that only mean each party is insured for their insurable interest. We say it doesn't mean that. We say rights and interests means exactly what it says on the tin. And I haven't got the transcript reference for you, but I can get it. When asked, Mr. Gailey, when Mr. Gailey was asked, does that include rights under the contract? He said yes.
Yeah.
So it's part of our analysis as to why it is permissible. And we say it's obviously permissible, but it's part of the reason why it's obviously permissible for the court to have regard to the underlying contractual scheme.
Is there anything you found that goes beyond what the previous Master of the Rolls, Sir Wilfred Green, said in general accident?
My Lord, no.
Which was very much in line with what you've submitted.
Well, let me... Whilst the authorities are not in the bundle, I have found a number of authorities that have referred to general accident. All of those authorities have simply dealt with the question of whether insurance is joint or composite.
Right.
This is the first case of which we're aware that this submission is being made, that the definition of rights and interests is not confined to insurance. I'm not saying in those cases there's any authority for the proposition that it is confined to rights and interests. The question simply hasn't arisen. And because parties have different rights and interests, the policies are by their nature composite rather than joint.
Okay.
That's the context in which it arises.
Yeah.
So, well, that's all I'm going to say in relation to rights and interests.
Yeah.
I said then I was going to move on to the individual grounds of appeal. Well, we have nothing to add to ground 1 over and above what Mr. Reed has said in his submissions and what we've said in our skeleton. Ground 2, we say, is based on fundamentally premised on a category error from Conway, where ground 2 is premised on the idea that the judge construed the JCT terms and worked on or implied the extent to which Conway was covered by the policy by reference to the contract in October. Well, we say on a plain reading of the judgment that's not what he did. His analysis goes up to and including the letter of intent and policy. So that point's a non-starter. But for all the reasons that are set out in my skeleton Mr. Reed submitted, it is permissible for the judge to look at the contract when dealing with questions such as intent, which require a broader analysis.
And you say permissible, see, for example, Coleman in...
Coleman National Oil Well, Coleman in Stonemakers, as approved by Mr. Justice Fraser in Haberdashers at paragraph 34. But yeah, for example.
Okay, I understand. Yeah.
In relation to ground 3, I've made my submissions. We say that ground 3 is essentially wrong, that the primary case, the judge did consider Conway's primary case and rejected it, and Conway's primary case is wrong. that being identified as an insured does not lead to any different route to cover. The only point that I would add in relation to ground 3, and it's just to deal with a short issue that my lady raised, is in relation to the dispute as to whether or not there was a concession. The point that we make, and I believe the point the RFU makes as well, is they don't think they made a concession, but if they did, we didn't, and the point was fully argued at first instance. So we don't understand where that point takes anyone.
No.
In relation to ground 4, we say that the correct test, because this is Conway's alternative case, that it was an undisclosed principle. Well, its primary attack on that is that the judge made the wrong findings of fact in relation to authority and should have relied on the discussions between Higgs and Morris, which I'm not going to cover because they've been done to death.
No.
But the judge made his views very clear at paragraphs 107 and 108 as to the conclusions he reached about their evidence, and then at 125 as to the weight he placed on them in the ultimate assessment.
No.
But if, on Conway's case, it is to be treated as an undisclosed principle, that follows the cumulative process in any event set out in Collinvo, follows Mr. Justice Coleman's step 1 or category 1 assessment of authority and intent in National Oil Well, and that's precisely what the judge did.
Yeah.
And finally, in relation to ground 5, we adopt Mr. Reed's submissions, but there is one paragraph from excuse me, one paragraph from National Oil Well that I just wanted to take you to. So if I could ask you to take up the authorities bundle and go to page 87.
Yeah.
Well, our submission here is that not only is Conway's case wrong as a matter of principle, it's wrong as a matter of commerciality. And if your lordships, I don't know if you've sidelined this yesterday, so I'm just going to say in column 1, from in determining.
Hang on. Column 1 in determining, yeah.
Down to the bottom of column 2. I mean, you could probably stop it on after the discussion of Stone Vickers. But the key point is at the bottom of column 1, the top of column 2. If the provisions of the contract clause limit the cover available to a scope less than the full scope provided by the policy to Davies, the waiver clause has the effect of protecting the subcontractor against subrogated claims. And then the conclusion is the policy would limit the cover with one hand and indirectly by waiver of subrogation remove the limit by another hand, which Mr. Justice Coleman describes there as being a remarkable result. And given that I've dealt with the meaning of rights and interests, which is relevant to the respondent's notice point, I'm not just going to repeat those submissions in the sum.
Yeah.
So my lords and my lady, unless I can assist you any further.
Just give me a minute.
One second.
Thank you very much, Mr. Eater.
My people has just given me a transcript reference for where Mr. Gailey said that rights and interests apply to contract rights. So, yesterday, page 128, line 25 to 129, line 1.
Transcript page
128, line 25 to 129, line 1.
I like that, Mr. Wheater, when you refer to your people.
Pupil.
Oh, pupil.
Pupil,
Sorry, I
pupil.
thought you said my people. I thought that sounded incredibly regal.
I wish I was that grand, my lord.
Yeah, no.
It wasn't just my lord. I thought that first.
Well, pupil.
Pupil.
Fine. Congratulations to your pupil.
And your people.
All right. Thank you very much, Mr. Eater. Yes, Mr. Golly, is there anything in reply?
There is, my lord.
Yeah.
My lady, my lords, may I begin with Mr. Reed's submission that if ground 1 fails, so too do grounds 3 and 4, and Mr. Wheater's submission that ground 4 is an attack on findings of fact. We do not accept those submissions. Ground 1 is that the judge required Conway to demonstrate a common contractual intention to eliminate liability and create a fund of sole recourse. That's ground 1. As you know, we say Conway did not have to demonstrate this in order to prove it was co-insured or succeed. It only had to show that it was insured to the same extent as the RFU. That's all it had to show. That's our issue with, that's the issue in ground 1. We say, look at the situation of Hall in Co-op, where there was nothing in the collateral warranty about insurance. We say, look at the situation in Petrofina, where on any view, there was nothing in Mamaway's subcontract about insurance. Both Hall and Mamaway established that there was co-insurance, and because they established that there was co-insurance, they had a co-insurance defence. Now, very briefly, in response to Mr. Wheater's analysis of Petrofina, I won't take your lordships to it, but the judge's reliance on security makes no difference at all to the question of whether Mamaway is insured or whether there is a term in Mamaway's contract providing for insurance. The question of whether there is a mechanism for security, the mechanism is security or an implied term, can't make a difference to whether or not Mamaway's subcontract contained provision for insurance. It did not, and yet the judge found they were co-insured. But we say, even if we are wrong on ground 1, grounds 2, 3, and 4 succeed. It appears now to be common ground that if, on the principles of agency, Conway is co-insured in respect of the loss in question, then the claim for insured losses falls away. So grounds 2 to 4 are freestanding on that basis. The error of law that we rely on in relation to grounds 2 to 4 is that the judge's finding that the extent of authority and intention was limited to what was in the underlying contract is wrong. We say that was a finding of law, and we say it was incorrect. And that is set out in our skeleton. Now, I will give your lordships quickly the references for each ground where that analysis is set out. For ground 2, it's paragraphs 45 and 46 of our skeleton. For ground 3, it's paragraphs 72 to 74 of our skeleton.
Sorry, give me that reference again.
For ground 3, my lord,
Yeah.
it's paragraphs 72 to 74.
(33 to 74).
72 to 74, man. 72 to 74.
Sorry. Yeah.
And for ground 4, It's paragraphs 97 to 104.
Did you say his findings was a finding of law? As you said.
Yes, my lord. That what he's saying there, and I will take your lordships to the specific part of the judgment that I rely on very shortly. But we say that what he's finding is not that this is a multifactorial exercise where you look at what's in the contract, you look at what's communicated between the parties, and you make a decision on that basis. That what he's finding is that what is in the contract overrides the communications between the parties. That overrides his findings of fact.
Yeah.
On our analysis of the judgment, the exercise the judge conducted was not the exercise in Petrofina. Sorry, was not the exercise in National Oil Well.
No.
The exercise in National Oil Well was one of starting with the contract, and given that the contract did not provide for authority and intention, looking to see if there was anything else that provided for authority and intention. That, my lady and my lords, is what I accepted as being the correct exercise. Starting with the contract, and then, if that does not provide for authority and intention, looking to see if there are other matters that provide for authority and intention. And we saw that in that case, in National Oil Well, even in circumstances where the policy provided that the contract, the underlying contract was king, even where there was a provisions to the contrary clause, the judge was prepared to look for authority and intention in communications, in words, in conduct. But on the facts of that case, he found no evidence of those things. That is Petrofina.
No, that's National Oil Well.
Sorry, my lord. Thank you, my lord. That is National Oil Well. Mr. Justice Coleman's exercise is not one of weighing one against the other, one of finding that the contract overrides other matters. It is searching for other communications of intention and authority, but finding none. And my lords, my lady, if we can please go to Core Bundle 78. And paragraph 109 of the judgment, please.
100, sorry.
109.
So immediately after 1078, which we've been focusing on, now
Yes.
109.
109, my lord. At paragraph 109 of the judgment, the judge states that the fact that Conway did take out insurance is a factor supporting its interpretation of the dealings between the parties. That is unquestionably a finding of fact that the judge makes in Conway's favour.
Yeah.
He then notes Conway's case on authority and intention as pleaded at paragraph 109 of the defence. And unquestionably, he there captures Conway's case correctly. That Conway is saying, in its defence, that authority and intention were communicated. If one reads on from however, please, and to the end of the paragraph, please. what is happening here is that he is making the finding that supports Conway's case on authority and intention, that these matters were communicated, that they're supportive. And then he's finding that is overridden by the letter of intent, the policy and the contract. Because those things do not indicate the same as the communication, then the position is as set out in the letter of intent, the policy, and
Why is that a finding of law, as you put it, rather than a finding of fact and...
Well, it's a legal analysis. The complaint is a complaint. The complaint we make is not a complaint that his finding of fact is wrong. It's a complaint about the way in which he analyses these facts. That he finds matters that support Conway's case, but then finds that that is overridden because on his reading of the law, it is the letter of intent and the contract that dictate whether...
Well, we have to be very careful about glossing what the judge said. We can read what he said at 109.
Certainly, my lord. Certainly, my lord.
And 109 has to be... You can't stop at 109. You have to go on. 110, 1110, 118, etc.
My lord, my lady, we also say on grounds 2 to 4 that the letter of intent does not contain any relevant obligation to insure, and to the extent that the judge was looking at the subsequent contract rather than the letter of intent, he was wrong to do so. And if I can now take your lordships to the case of Twintech, much heralded case of Twintech.
Yeah.
If we go, please, to internal page 154 of Twintech.
Yeah.
And look at paragraph 22. Paragraph 22 here sets out the terms of the letter of intent in this particular case. And we note that the letter of intent states that it was the main contractor's intention to award the contract for slab works, but it was not yet in a position to do so. Now, I highlight that because Mr. Justice Edward Stewart considered it important that the letter of intent made clear that the award of a contract would not automatically follow.
Unlike this case.
Well, we say not, my lord, and I will...
We keep looking at these cases to look at the facts.
Well,
I must say, I'm bound to say, I'm used to being taken to authorities to see the principle. Can we see the principle that you rely on Twintech for? An adjudication case in relation to injunctions against adjudications, where the principle for the purposes of letter of intent is in paragraphs 18 to 21.
My lord, we
So
say...
what are we looking at?
Paragraph 42 to 43, please, my lord, at page 157. And if your lordship looks at paragraph 43, we see that Mr. Justice Edward Stewart concludes that the obligation in the letter of intent to carry out works in accordance with the regulatory form does not import the insurance obligations.
Yes.
That's the proposition. That
On the construction of that letter of intent.
it is, my lord, which is
I
why
thought we were looking at this for a point of principle.
Well, my lord, I was attempting to show your lordship that the features of the letter of intent that led to that conclusion, and then I will go to our letter of intent and show you, with your permission, that those same features are present.
Just so I know, we're comparing what's paragraph 22 with our letter of intent. We're going to compare the two.
The two features in paragraph 22 that I wanted to highlight were the fact that it states we are not yet in a position to enter into a contract, which is something the judge considered relevant, and the fact that it provides that the works are to be in accordance with the documents below, and the phrase there I want to highlight is in accordance with, and the documents below include the DOM 2 form.
Include?
The DOM 2 form, my lord.
Where?
Well, if we go back
I thought
to...
that was precisely what it didn't do.
No, it did, my lord.
Where's that in paragraph 22 then?
So, paragraph 22, it says, proceed with all works necessary in accordance with the documents below.
Yeah.
The documents below include Appendix A,
Yeah.
and Appendix A includes the DOM 2 form.
Where do I get that from?
If we go back to
I'm looking at paragraph 27, Mr. Galley. I may be wrong, but it looks to me as though that's saying it would be fatal to the submission that they must be taken to conclude the contract on the basis of the terms of the DOM 2 form.
my lord, the DOM 2 form was one of the... I'm struggling to find the reference to where.
Well, let's assume that that's right. Yeah, okay.
The DOM 2 form was one of these documents.
As I say, we're assuming for the sake of speed that that's right.
Thank you, my lord. And the analysis that the judge is carrying out, if we go back to page 157, from 42 onwards, is an analysis of trying to ascertain which of the parts of the DOM 2 form are then incorporated into the letter of intent. That's what he is doing here.
Because that was his interpretation of in accordance with.
Yes, my lord. He is interpreting in accordance with to determine which of the parts of the DOM 2 form are incorporated.
Where's this going?
Well, my lord, if we go to our letter of intent at core bundle 225.
Mr. Garley, let me cut to the chase. You've pleaded that this contract was dated the 19th of June.
Yes.
And it was retrospective.
Yes.
You haven't pleaded that in some way there are some provisions that don't apply.
My lord, we've pleaded that the provisions that apply are the provisions that were necessary for the carrying out of the works. And if we look, let me try and
Show me this in your skeleton argument, where the twin tech point is taken.
My lord, there's no reference to twin tech in.
All right, where the point is taken that in some way there's a difference between the position under the letter of intent and the position under the contract that was subsequently agreed.
My lord, our ground too is that there was no.
I repeat the question.
My lord, our ground.
You're seeking to make a distinction between the two, and I need to see where that's set out.
My lord, our ground too is that.
The ground two is a different point.
It is not, my lord.
Mr. Garley, I'm not arguing with you. I'm sorry. I am concerned about the way in which the arguments have dotted about. You've heard what was said about the taking of points in some of which were new. I need to see the point in your skeleton that you're dealing with as part of this reply.
My lord, the Volker Fitzpatrick is raised in.
Mr. Garley, I don't think that's a
Certainly,
difficult
certainly,
question.
my lord. Certainly, I will answer the question. So this is part of ground two.
Yeah.
My lord, the best I can do, and it won't be satisfactory, is that ground 2 proceeds on the basis that there was no preceding.
You just told me I was wrong to put it to you that it wasn't in your skeleton.
Well, my lord.
I mean, some of my colleagues might take offence to being told they were wrong that something wasn't in your skeleton. It's not in your skeleton. So what I need to understand, therefore, and I don't think this is unfair, is to know what the proposition is that you're advancing that is relevant to this appeal.
My lord, the proposition that's being advanced, the proposition that was advanced in ground 2, is that the judge relied on a subsequent contract to construe the content of the policy, and that the only relevant contractual obligation, the premise of ground 2, is that the only relevant contractual obligation in relation to insurance is what is in the subsequent contract. And I'm attempting.
I understand that point.
I'm attempting.
That's got really nothing to do with twin tech. I thought you were trying to seek to draw some distinction between the position covered by the letter of intent until the building contract was entered into and the position thereafter.
All I'm trying, forgive me, my lord, all I'm trying to do, and I'm evidently not doing it very clearly, all I'm trying to do is to make good the proposition that there was no preceding contractual obligation, no contractual obligation prior to the inception of the policy. And that's a point that I was making yesterday by reference to the letter of intent. And the twin tech I accept was something of a sideshow, a distraction.
Well, the letters of intent, as I read them, are different.
Well,
for example, the way in which the anticipation of the full contract is expressed. Dom, as I read it, Dom 2 in Twin Tech was just a standard form, which is
that's correct.
And whereas in this case, the provisions of paragraph 3 and 5 of our letter of intent are much more precise, it seems to me.
But my lord,
paragraph 3 refers to we've been told, not to a standard form, but to effectively a fully fledged contract which just hadn't been signed. And paragraph 5 contains provisions which simply aren't repeated in the letter of intent, so far as I can see in Twin Tech that you referred us to so far.
but my lord, what is important, we say, is to look at paragraph 4, which describes the content of the work. And if your lord,
Important to what?
well, my lord, this contains the thing that was damaged was the ductwork. The thing that caused damage was the ductwork. That was the thing that's problematic. That is the thing of which complaint is made. They are complaining that our Conway's defective workmanship in relation to the ductwork caused damage to the cables.
Yeah.
This letter of intent does not include any ductwork at all. If your lordship looks at what is included, which is in paragraph 4.
And does the judge find that?
So the judge does not analyse the issue.
Let's stick to the judgment and your submissions in reply to the submissions from Mr. Reid and Mr. Wheater.
Well, my submission, my lord, is that it is the reason that it's incorrect to characterise this document as creating a obligation to procure insurance. The reason that's incorrect is because the obligation to procure insurance could only ever be in relation to the matters in paragraph 4 here. The obligation to procure insurance could only ever arise in relation to site mobilisation, set-up, undertaking site measurements, undertaking all other
That's the
services.
point you're making in reply at the end of the second day in the Court of Appeal without it being in your grounds of appeal or in your skeleton argument.
It's being made. It is, my lord.
Yeah, well, it's not open to you.
I will move on, my lord.
We need to have some, we're relatively flexible, but we need to have some procedural rules to maintain fairness. Yeah.
So, going back then to our complaint on grounds 2 to 4, as I'd stated before we went into Twintech, our complaint was that the judge's analysis was not to look for communication of authority and intent separate from the contract, but to consider that the contract overrode communications of authority and intention, and this really is mopping up a point that arose yesterday. If we go please to core bundle 76, and within it paragraph 100 again. Ten lines down, the judge is discussing the start-up meeting. And this is something I took your lordships to yesterday, and my Lord Coulson expressed the concern that this was a new point and something that had not been dealt with in the skeleton. For your lordships, in your ladyship's note, the reference to where it is dealt with in the skeleton is paragraph 99. But the point that I took from it, and if your lordship, if it would help your lordship, I can go to the skeleton now and show you in the skeleton.
You carry on.
If we look at paragraph 100, 10 lines down, the judge is discussing the start-up meeting chaired by Mr. Higgs and attended by Conway and the Rugby Football Union on the 4th of July. So that's 13 days before the policy is incepted. And what is minuted here is an intention to establish not JCT option C insurance, but if your lordship looks at the minutes 2.4.1, the intention was to establish stadium work project insurance, although this would not cover plant welfare and equipment. So we say, my lord...
But this hasn't been achieved.
But this hasn't been achieved. When it is achieved, when the project insurance is established, Conway will be notified and they will need to submit their claims to Marsh. So that's what the judge is finding happened. And that's relevant, we say, because this is a communication of authority and intention immediately before the policy is adopted, with all the parties facing each other. And what is being communicated is not an intention to enter into a contract on JCT terms, but it's an intention to enter into the project policy with the very limited exceptions that are set out in the project policy. And if I can make good on that simply by going to core bundle 177, We are within the policy exclusions. Your lordships, your ladyship can see that on the previous page. We're within the exclusions, and the exclusion there at 11 is the exclusion that is being discussed at the pre-start-up meeting.
Where's that in paragraph 100?
So, my lord, in the quote in paragraph 100, your lordship will see the intention was to establish stadium work project insurance, although this would not cover plant, welfare and equipment.
Yeah, but this is dealing with other things too,
It is, my lord.
including temporary buildings.
But my lord, the submission that we make is that this communication of intention, very shortly before the inception of the policy.
These minutes,
my
yeah.
lord. These minutes.
These are minutes that the judge referred to.
Yes, my lord.
And he then says, Mr. Higgs was clear, he believed the insurance to be obtained was going to be more extensive than that envisaged in the standard terms of the JCT contract.
Yes, my lord.
Yeah.
But we say there's no suggestion that this did not occur. There's no suggestion, it is accepted, and the judge, we say, found.
Well, we see what his finding was at 101.
My lord,
I mean, what you appear to be adding a gloss. You just need to know what the gloss is.
well, the gloss is that 100 also comprises a finding of fact, and that the finding of fact is that this occurred, that this meeting occurred.
What's the effect of it?
The effect of it is that very shortly before the policy was incepted, we have minuted here.
What's the effect of it?
Well, my lord, what is minuted here, what is recorded here, amounts to the communication of authority and intention.
So this is the answer.
My lord?
So this is the answer on your case.
Part of it, my lord. Part of it.
No, that must be the effect of it.
Yes, my lord.
The gloss that you add is to say, well, there we are. As at the 4th of July, that was the position.
There is a communication of authority and intention.
Yeah.
And what is communicated is in line with the terms of the policy and not in line with the terms of JCT option C, which do not include exclusions for...
Well, the judge took all this into account.
He did, my lord.
He took all the evidence into account and reached his final conclusion at 125.
He did, my lord.
So,
We don't say that this. We don't say this wasn't taken into account. We don't say it wasn't taken into account. The complaint that is made here is that the analysis that the underlying contract trumps everything else is the incorrect analysis, and the correct analysis is that one looks for communications of authority and intention. And if one finds communications of authority and intention, as at the point policy was incepted, then cover exists, which is coextensive with those communications of authority and intention.
well, for my part, I don't accept that it's a legal analysis, simple legal analysis that leads the judge to a conclusion, but it's an assessment of all of the facts and the law together behind his conclusion at 125. That's how it seems to me. But of course,
Thank you.
we'll all consider your submission.
Thank you.
Yeah.
My Lord, I'm just seeing what more I need to say that might be of assistance to the court. As to the dispute, to the extent that there is a dispute as to Mr. Reed's concession, I want to make clear to the court that we are not relying on any concession by Mr. Reed. That's not part of the ground itself. It's not in the ground itself. It's in the skeleton discussing what happened, but it's not part of the ground that Mr. Reed conceded a point on the difference between a named insured and an identifiable insured. What we resist is the suggestion that what is in the skeleton argument, what is said by Conway in the skeleton argument on this point, deliberately misunderstands what.
Never said it was deliberate, absolutely not.
And to the extent that it helps your lordships, in Mr. Reed's own unagreed bundle at tab 3, page 52, is Conway's skeleton below, the trial below, which in turn quotes the RFU skeleton saying that it accepts Conway was a named insured. So that was the basis of what we said to the Conway's own skeleton accepting that the RFU was a named insured. But we've never sought to hold them to that.
Named on the basis of capable of being identified.
Well, it just said named insured, my lord.
Yeah.
There was no gloss on it in
But
the
that
skeleton.
I mean, I think everybody's agreed it's capable of being identified.
Yes, my lord.
Because everybody's agreed that Conway, the word Conway doesn't appear, unlike Barclays Bank, although that's a separate point. But the word Conway doesn't appear, but if you looked at the documents, you'd have seen they were the people who were going to be doing, and in fact had started the preliminary works for the ductwork.
Yes, my lord. My final point is in relation to ground 5, and it's the commercial purpose of project insurance. Now, the position of both the RFU and CSP is that the operation of the waiver of subrogation clause in circumstances where the co-insurance is not coextensive would have no commercial purpose. And we say that that is not right. Because the purpose of project insurance is not simply to prevent subrogated claims between those who are covered, but it is to prevent claims between parties that have an ongoing working relationship on a project. And what we say is consistent.
Isn't that two different things, though? I mean, I understand that. I understand the point. To prevent claims between parties, I get that completely. But this is a waiver of subrogated claims.
That we say, my lord, is the point. So subrogated claims can only be claims where there has been some liability created as between two parties to a project, and the insurer is exercising step-in rights as between those two parties. Now, it's common ground that where both parties are co-insured to the same extent, that waiver of subrogation operates.
Yeah, and would be implied if it wasn't expressed.
Precisely, my lord.
Yeah.
But we say that there is a further purpose to project insurance, which is that even where parties are not insured to the same extent, it would be disruptive to a large ongoing project to have the parties litigating against each other when they should be getting on with the works. And we say that that is also a purpose of project insurance and the waiver of subrogation clause in project insurance to prevent such claims. And we say, my Lord, that that is consistent with what Lord Coulson says in Guard Marine. If we could go to Authorities Bundle 255.
Yeah.
And we are within the speech of Lord Coulson. And
Yeah.
if your lordships could look at letter C.
Yeah. Yeah.
What Lord Coulson is saying there is that the commercial purpose of maintaining joint insurance in these circumstances is not just to create the fund itself that pays out, not just to create the pool of coextensive cover, but it is also to prevent claims between parties.
Yeah. But perhaps I put the point badly. That's on the premise that the insurance is coextensive.
Well, my lord.
What about the circumstances where it's not?
Well,
I mean, on that, you have what Mr. Justice Coleman said in National Oil Well.
so
that effectively you would be acquiring insurance, a co-insurance defence, where on this premise, just on this premise, you wouldn't otherwise have it.
So to a limited extent you would. To a limited extent you would. But
Well, okay, but in this case, on the, because the loss isn't covered by option C, assume that you're wrong on grounds 1 to 4, because otherwise the point probably doesn't arise. But assume that you're wrong on ground 1 to 4, but we've got ground 5, and we know there's that imbalance. Then in those circumstances, it's difficult, isn't it, to justify that on a commercial purpose basis in circumstances where you don't have cover, but you would say the waiver of subrogated claims somehow gave you effectively that cover.
so may I put it this way, my lord? It's important to look at what the cover might be and why it might exist. So in the situation where the cover is not, in the situation where the cover is not coextensive, then for losses that are not within the pool, as it were, Conway would not be insured in respect of damage caused to anyone other than the RFU. So if Conway caused damage to a third party, the insurer would not be required to indemnify Conway in respect of that under the terms of the project policy. So if Conway set fire to neighbouring property, let's say on this hypothesis, Conway would not be covered by that. But what the waiver of subrogation is doing is that in circumstances where either is insured in respect of a risk, either Conway or the RFU is insured in respect of a risk, the insurer pays out, and the commercial purpose of it paying out and then waiving subrogation is to prevent a claim between two parties to an ongoing project while the project is ongoing.
Well, we can't get too excited about an ongoing project, given that this was work for the Rugby World Cup in 2015, in which my recollection is England did disastrously badly, and they might have been better spent doing the money somewhere else, because I don't think it can be said that the Rugby World Cup in 2015 was very much of a success from the English point of view. But the point remains that on your analysis, this waiver provision would have the effect of protecting Conway against subrogated claims for which they were, if you were wrong about 1 to 4, uninsured.
It would have that effect, my lord, but it is wrong to say that that effect is the same as making Conway co-insured. It's not the same as
No, I'm not. I'm just dealing with that would be a remarkable consequence.
Well, my lord, we say that it serves a commercial purpose. Maybe not on the facts of this case, because the claim arises after the works are finished. But as Mr. Reid said in his submissions, these project policies are designed for long-running projects. The Channel Tunnel project was his example, where parties face each other for year after year after year. And you want those projects to be able to be carried out without parties suing each other while they're ongoing. And the commercial purpose of paying an enormous premium for project insurance is not simply to create the pool that pays out, but we say it's also to prevent any claims between parties within the scope of the whole insurance. Any claims between parties within the scope of the whole insurance. And we say, my lord, that is not the same as making Conway jointly insured to the same extent as the RFU. It's not the same as that, because while vis-a-vis Conway and the RFU it would have that effect, it doesn't have that effect in relation to third parties. So if Conway causes some damage to something in respect of which, to some property of a third party, say, which is notionally within the scope of the insurance, and it would be a loss in respect of which the RFU is covered, but Conway is not covered, then the waiver of subrogation clause does not broaden the ambit of the insurance to give Conway protection in respect of that claim. It only does so in respect of claims where Conway and the RFU are facing each other.
Okay, well, I understand that submission. Yeah.
And my lord and my lady, unless I have any...
All right. Those are your submissions in reply. Thank you very much.
Thank you.
All right. Thank you all very, very much. You won't be surprised to learn that we will reserve our judgments. We will endeavour to do them as quickly as possible, but we can't make any promises. We will, once they're done, send them out in draft to the parties. I think I'm right in saying that the parties have provided a list of those people to whom the draft will be sent to my clerk, so it will be sent to those people. As you're all aware, the rules of confidentiality apply. You will be aware that there have been one or two unfortunate events in recent times where the judgments handed down in draft were then publicised, and that was found to be a contempt of court. So let's not get into that if we can possibly avoid it, please. So only the people on the list. When you do your returns, it's just typos and grammatical errors, not an exercise in re-arguing any of these interesting points. Thank you very much.